Patriots, buckle up. The United States Supreme Court has officially taken on a new Second Amendment case, and this one could change everything we know about our gun rights. The case is United States v. Daniel Himmani, and at its core lies a single question. Can the federal government strip you of your right to own a firearm simply because you use marijuana or another controlled substance? Let me tell you right now, this is not just about drugs. It's about power. The power of the Department of Justice, DOJ, to decide who is worthy of the Second Amendment and who isn't. And if they win this case, millions of law-abiding Americans could suddenly find themselves labeled as criminals. Here are the facts. Daniel Himmani is a dual citizen of the United States and Pakistan. He was charged under 18 U.S.C. Section 922G3, a federal statute that makes it illegal for anyone who is an unlawful user of or addicted to any controlled substance to possess a firearm. He wasn't accused of committing violence. He wasn't high during a crime. He simply admitted to using marijuana regularly. And that alone was enough for the federal government to say, you lose your Second Amendment rights. Now, the Supreme Court has agreed to hear this case during its upcoming term, likely in early 2026. That means we're standing at the edge of a decision that could redefine what it means to be a responsible gun owner in America. Because if the government can take your rights for using something that's legal in half the states, what's next? In this video, I'm going to break down exactly what 18 U.S.C. Section 922G3 means, how this case got to the nation's highest court, and why the DOJ might have made a massive, possibly intentional mistake that could reshape the future of the Second Amendment for all of us. When I first started looking into 18 U.S.C. Section 922G3, I realized just how vague and outdated it truly is. This law, which came out of the Gun Control Act of 1968, makes it illegal for anyone who is an unlawful user of or addicted to any controlled substance to possess a firearm. In the 1960s, that language was meant to target people actively abusing hard drugs while armed, heroin, meth, narcotics. But here we are, more than 50 years later, and that same wording is now being used to criminalize ordinary citizens who legally use marijuana in states that have approved it for medical or recreational purposes. The law doesn't define what unlawful user really means. It doesn't say how long after someone uses marijuana they lose their rights, or whether using a legal THC edible months ago would disqualify them. Federal agencies like the Bureau of Alcohol, Tobacco, Firearms, Explosives, ATF, interpret it as broadly as possible. According to the ATF's 2023 guidance, even admitting to occasional cannabis use could make someone a prohibited person under federal law. That means tens of millions of Americans could technically be charged for a federal crime simply because their state and the federal government don't agree. This law has become even shakier since the Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruen. That ruling said gun laws must align with the nation's historical tradition of firearm regulation. And guess what? There's no historical precedent for banning sober citizens from owning guns just because they use a substance the federal government disapproves of. After Bruen, courts around the country started striking down federal gun restrictions that didn't meet that standard, and Section 922G3 quickly became one of the most contested. From a constitutional standpoint, this case isn't about drugs. It's about the limits of government power. If the Founding Fathers didn't disarm people for drinking rum, why should the federal government be allowed to disarm someone for using legal marijuana in 2025? That's the question now sitting before the Supreme Court. Let's talk about the man at the center of all this, Daniel Himmani. He's a dual citizen of the United States and Pakistan, charged under 18 U.S.C. 922G3 for possessing a Glock 9mm pistol, roughly 60 grams of marijuana, and 4.7 grams of cocaine. The FBI searched his home, found the substances, and concluded he was a habitual marijuana user. He wasn't accused of being high while armed, nor of committing any violent act. But that admission alone was enough for prosecutors to say, you lose your Second Amendment rights. Now here's where things get complicated. Himmani's case is messy. According to court filings, he had contacts tied to the Iranian Revolutionary Guard Corps (IRGC), and even attended a memorial in Tehran honoring General Qasem Soleimani, who was killed by a U.S. drone strike in 2020. His mother was recorded praising the idea of martyrdom, and Himmani himself allegedly said he wouldn't report a terrorist attack if he knew about one. Those facts make him a terrible representative for a constitutional test case. It's why many legal analysts and gun rights advocates like myself believe the Department of Justice picked him on purpose. It's a classic strategy. Pick the worst possible defendant to make a law seem justified. As Attorney General Pam Bondi once said, bad facts make bad law.
We saw the same playbook with U.S. v. Rahimi, where the DOJ used a domestic violence offender to test another Second Amendment restriction. And now, by using someone linked to alleged extremism, they're trying to make the public associate gun ownership with terrorism and drugs. But that's exactly what makes this so dangerous. If the Supreme Court upholds the ban based on Himmani's case, that ruling won't just apply to him. It will apply to every American who uses cannabis or other controlled substances, even legally. This case could either reinforce government overreach or finally roll it back. It's not about defending Himmani as a person, it's about defending the constitutional principle that the government doesn't get to decide which citizens are worthy of rights. After Bruen, the lower courts have been locked in open conflict over 18 U.S.C. 922 G3. The problem isn't just interpretation, it's consistency. One federal circuit says it's unconstitutional, another says it's perfectly fine. That kind of division is exactly what forces the Supreme Court to step in. The Fifth Circuit Court of Appeals, covering Texas, Louisiana, and Mississippi, ruled that the statute violates the Second Amendment. In United States v. Daniels 2023, the court found that the government had no historical justification to disarm a sober individual just because they occasionally used marijuana. The judges pointed out that the founding generation never enacted blanket bans against nonviolent citizens for lifestyle choices. Then came United States v. Connolly 2024, where the same court doubled down, calling the ban unconstitutional again because it punished individuals without any evidence of current impairment or danger.
But in the Seventh Circuit, which covers Illinois, Indiana, and Wisconsin, the courts upheld the law. Their reasoning? They said Congress has the power to disarm anyone who might pose a threat, comparing drug users to drunkards or the mentally ill. Meanwhile, the Eighth Circuit struck the law down in a slightly different way, saying it went beyond the scope of the government's historical authority. This three-way split between the Fifth, Seventh, and Eighth Circuits is why the Supreme Court took U.S. v. Himmani. It's not just about marijuana anymore. It's about clarifying what Bruen actually means. Can the government make entire groups of people presumptively dangerous, or does each individual deserve due process before losing a constitutional right? Gun rights groups like the Firearms Policy Coalition, FPC, Gun Owners of America, GOA, and the Second Amendment Foundation, SAF, have filed amicus briefs supporting Himmani, arguing that Section 922 G3 cannot survive under Bruen's test. On the other side, anti-gun states and public health organizations are lining up behind the Department of Justice, warning that invalidating this law could make it harder for law enforcement to manage risk. To me, this fight isn't just a legal debate. It's about whether the federal government can define you as dangerous without proof. Because if they can label millions of people unfit for their rights, the Second Amendment stops being a right and becomes a privilege. Now that the Supreme Court has agreed to hear United States v. Himmani, the stakes couldn't be higher. This isn't just a marijuana case. It's a test of how far the federal government can go in limiting rights based on lifestyle or medical choices. Right now, nearly 24 states and Washington, D.C. have legalized marijuana. Millions of Americans, including veterans using THC for PTSD and patients managing chronic pain, are following state law in good faith, yet under federal law, they are classified the same as felons. The Department of Justice argues that these individuals are too risky to trust with firearms, but the Fifth Circuit made it clear, risk cannot replace due process. This issue also cuts deep into the 10th Amendment, which reserves powers to the states. Federal law is directly clashing with state sovereignty. When Washington overrides a state's decision to legalize marijuana and then criminalizes gun owners who comply with that law, that's not federalism, that's coercion. The broader danger here is how this precedent could expand. If the government can strip you of rights because you use a federally controlled substance, what's next? Could anxiety medication, antidepressants, or prescription opioids fall into the same category? Once the logic is accepted, there's no stopping where it spreads. As one FPC attorney said in a recent filing, today it's cannabis, tomorrow it could be caffeine if the government decides it poses a risk.
From a policy standpoint, this case will decide whether the Second Amendment protects individuals regardless of lifestyle, or whether it can be selectively applied. From a constitutional standpoint, it's about whether rights are inherent or conditional. If Himmani wins, Section 922 G3 could be struck down nationwide, restoring rights to millions of gun owners. If the DOJ wins, it will set a precedent allowing the government to disarm entire classes of citizens without proof of wrongdoing. That's what's really at stake here. Not just marijuana, but the very definition of freedom in the United States. When I look at United States versus Himmani, I don't just see another gun case. I see a turning point. The Supreme Court's decision in this case could define how far the federal government can go in deciding who deserves rights and who doesn't. It's not really about marijuana or even Ali Himmani himself. It's about whether freedom in America is permanent or conditional. Here's the reality. If the Department of Justice, DOJ, wins, the government will have the legal precedent to disarm millions of law-abiding Americans without any proof that they pose a threat. It would mean that your constitutional rights could depend on what medicine you take, what state you live in, or what the federal government decides to label dangerous. That's not liberty. That's control. And that's exactly what the Second Amendment was written to prevent. If Himmani wins, this could become one of the most significant pro-2A rulings since Bruen, 2022. It would reaffirm that the Second Amendment protects the people, not just those who meet Washington's ever-changing definition of compliance. It would also send a clear message to the DOJ and lower courts. You cannot criminalize ordinary citizens for behavior that poses no harm and has no historical precedent for disarmament. I've covered hundreds of cases like this, but this one feels different. It feels like a test, not just of the courts, but of the American principle of individual liberty. Whether you're a hunter in Texas, a veteran in Colorado, or a medical patient in Florida, this case touches every one of us who believes that rights should never hinge on government approval. So here's my message. Stay informed, stay vocal, and stay vigilant. Support the organizations that are fighting for your rights, FBC, GOA, SAF, because this battle isn't over. The court will hear arguments in early 2026, and until then, we need to keep the pressure on. As I always say, stay safe, stay vigilant, stay free, and carry a gun. Because in times like these, freedom needs defenders more than ever.